Hello, I'm Judge Michael R. Casal of counsel at the law firm of Greenbaum Rowe, Smith and Davis, located in Roseland, New Jersey. I was a Superior Court judge for 20 and a half years in Essex County, the last 6, the head matrimonial judge. And today's presentation will deal with From Complaint to Judgment, New Jersey Divorce Law. It's sort of a nuts and bolts seminar, a practical guideline in handling a divorce case from complaint through the judgment of divorce. It's not meant to deal with post-judgment issues, and many of the general topics I will discuss with you can be really separate subtopics for their own seminar. So this is a general guide to divorce practice in New Jersey. Obviously, as with any case, it is started with a complaint for divorce. The complaint must have the proper venue. That means that one or both parties must live in the county in which the divorce complaint is filed or in which the cause of action arose. Jurisdiction in New Jersey simply means that the must be a cause of action which sets forth in specificity the grounds upon which a party is seeking a divorce, and also that the parties have resided, at least one of the parties have resided in the state of New Jersey for 1 year. The causes of action are set forth in New Jersey Statute Annotated 2A:34-2. These are the causes of action that will need to be pled in the complaint for divorce. Adultery. If you are filing a complaint for divorce alleging adultery, you must name in the complaint the person with whom the adulterous relationship has occurred. Willful and continued desertion, which must be for a time period of 12 months or more, in which the parties have ceased cohabitation as man and wife. You could have a cause of action for extreme cruelty, and that can be physical or mental. It must endanger the plaintiff's safety or create a condition wherein it's unreasonable to expect continued cohabitation. You must wait at least 3 months from the last cruel act to file the complaint. In other words, from the date of the complaint, the last act of cruelty must have occurred longer than 3 months from that date. A common cause of action is for separation for at least 18 months. That's continuous separation. No hanky-panky fooling around in that time, with no reasonable prospect of reconciliation. There are some unusual causes of action: voluntary addiction to narcotics or habitual drunkenness, institutionalization for mental illness, which must be 24 or more consecutive months after marriage. If a defendant has been imprisoned for 18 consecutive months before you file the complaint, you have a cause of action for that. One of the less common causes of action in your complaint is deviant sexual conduct without the plaintiff's consent. And then you have the most common pled cause of action, and that's irreconcilable differences which cause a breakdown of the marriage. This is what's known as a no-fault divorce. New Jersey is a no-fault state. I think some individuals believe that they will get more in a financial settlement if they plead some of these other causes of action. Well, if there's irreconcilable differences for at least 6 months prior to filing the complaint with no reasonable prospect of reconciliation, then that's the no-fault divorce.